Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Daniel Aiman with the matric number 2310295. Today, my group and I will be presenting regarding our constitutional law question, which is pertaining to constitutional rights and religious authority. Barisa has just completed his secondary school studies. He does not know how to read the Quran and has never attended any religious classes. While waiting for his SPM results, he spent most of his time reading various religious materials online. After a few weeks of learning about Islam from different websites, he believes he has gained sufficient knowledge and feels obligated to share the teachings of Islam with others based on a hadith that states, "Convey from me even if it is just one verse." With this motivation, Barisa went to a mosque near his home and began preaching about Islam. However, he was interrupted by the Imam of the mosque, who prohibited him from continuing to teach there. In response, Barisa expressed his anger to the Imam, asserting that as a citizen of Malaysia, he has the constitutional right to speak and teach. He argued that he has the right to go anywhere in the country, including staying in the mosque. Furthermore, as a Muslim, he believes he has a religious obligation to spread the teachings of Islam, as enjoined in the Hadith. Therefore, he contends that no one, including the Imam, has the authority to restrict his constitutional rights. Discuss this situation from constitutional law and human rights perspective. There are two issues that we can deduce from our scenario today. The first issue is whether Barisa has the right to teach in the mosque, and the second issue is whether the Imam has the right to restrict Barisa's teaching in the mosque. In solving the first issue of whether Barisa has the right to teach in the mosque, it is important for us to identify the provisions related in order to solve this particular issue. So the first provision that we can identify is based on Article 10 Clause 1 of the Federal Constitution, which basically guarantees Malaysian citizen the right to freedom of speech and also expression. So this includes that the citizen have the liberty to express opinions and ideas without undue interference. First and foremost, the specific clause that we can use under Article 10 Clause 1 is Article 10 Clause 1A, which basically says that every citizen has the right to freedom of speech and also expression, where basically this right encompasses the ability of the citizen to express opinions, ideas, or information without any restriction coming from the government or even undue interference. The next clause that we can also use under Article 10 Clause 1 is Article 10 Clause 1B, which basically mentions that all citizens have the right to assemble peaceably and without arms. What this means is that individuals can actually gather for meetings or even protests as long as the assembly is actually peaceful and does not involve any weapons. However, it is important to note that this right is actually not absolute because the article itself basically states that it is subjected to clause 2, 3, and 4, which basically mentions that the parliament can actually impose restrictions deemed necessary in the interest of national security, public order, morality, or even to protect the privilege of the parliament as well as any legislative assembly. So moving on to another provision that we can also use is under Article 11 Clause 1, which basically mentions that every person has the right to profess and practice his religion and subject to Clause 4 to propagate it. What it means here is that every person has the right to profess, practice, and also propagate their religion as long as it adheres to Clause 4 of the Article 11. So basically, in Clause 4, it mentions state law and in respect of the federal territories of KL, Labuan, and Putrajaya, federal law may control or restrict the propagation of any religious doctrine or belief amongst persons professing the religion of Islam. What this means is that individuals have broad rights to religious belief and practices and even the right to propagate the religion, particularly among Muslims. However, it can be lawfully limited by the state enactments to preserve the Islamic doctrine and also the public order. The next provisions that we can use in our scenario in terms of human rights perspective is Article 19 of the Universal Declaration of Human Rights, which basically says that everyone has the right to freedom of opinion and expression, where this right includes freedom to hold opinions without interference and to seek, receive, and impart information and ideas. What it means here is that everyone has the right to form and express their own opinions freely, such as the freedom to seek, receive, and also share information and ideas without any interference. So the next provision that we can actually apply to our scenario here is basically based on the case of Utusan Melayu versus Datuk Seri Diraja Adnan, basically where it discusses regarding Article 10 Clause 1A of freedom of speech and also expression. So what happened in this case is that the respondent in this case, which is the Menteri Besar of Pahang, had the locus standi to sue for defamation in relation to an article published about his performance as a public official. However, the court ruled that public officials, particularly those holding significant positions like the Menteri Besar here, should actually be open to public criticisms regarding their administration. So this reasoning was actually given based on the English case, Derbyshire County Council versus Times Newspaper Limited, where basically they held that the government bodies and also public officials should actually not be allowed to sue for defamation based on public criticisms of their official duties, as actually this would inhibit free speech and also stifle legitimate discussion. So therefore, in this case of Utusan Melayu versus Datuk Seri Diraja Adnan, the court found that the respondent was essentially suing in his official capacity. So what that means is basically he is not suing as a private individual, but he is suing because of the authority or responsibilities he held in his official role. So therefore, he had no standing to bring a defamation suit. The court emphasized in this case that allowing such a suit could actually have a chilling effect on free speech, particularly when it comes to criticizing the government and also public officials' conduct. So therefore, this is seen as contrary to the public interest and also the fundamental rights of freedom of speech and also expression as protected under Article 10, Clause 1A of the Federal Constitution. So the next provision or the next case that is applicable to our scenario here or to solve our particular issue is the case of Mahmad bin Daud versus Government of Malaysia, where it discusses regarding the propagation. So in this case, what happened is that the petitioner argued that Section 298A subsection 1 of the Penal Code, which basically mentions that it is a crime to do or say anything that causes or is likely to cause religious disharmony or hatred, and it also includes that actions that may affect harmony or unity between the people of the same or different religions, where they argued that this particular law may interfere with the constitutional right to spread one's religion as protected under Article 11, Clause 1 of the Federal Constitution. So the petitioners in this case claim that any restriction on the propagation of religious beliefs that were peaceful and also non-violent would be unconstitutional. Although the petitioners in this case were actually dismissed, the court reasoned that the right to propagate one's religion could be restricted only if such propagation led to the activities that could cause disharmony or public disorder. So the court emphasized that the law sought to prevent actions that might disturb the harmony between the people of different religions group rather than prohibiting the religious activity itself. So in applying our provisions to the scenario under Article 10, Clause 1A of the Federal Constitution, where basically Barisa has the freedom of speech and also expression as a Malaysian citizen. And his act of preaching in the mosque was actually considered as a sincere desire to share the Islamic teachings he had learned from the websites, which was intended to benefit the Muslim community. And not only that, according to Article 10, Clause 1B, where Barisa was not actually organizing a protest or disrupting the mosque operation, but just only conversing and also sharing the knowledge with the other Muslims, where according to the facts, as we can see, it was peaceful and did not involve any weapons. And most importantly, subjected to clause 234 of the Federal Constitution of Article 10, there is no indication that his preaching caused any disruption or incited any violence or even affected public order. And therefore, it can be seen that any interference with this freedom must be examined strictly under Article 10, since Article 10 actually are the rights, fundamental liberties, and also limitations that must be reasonable and not arbitrary. And furthermore, in applying Article 11, Clause 1 of the Federal Constitution as well, Barisa, a practicing Muslim, preaching to fellow Muslims can be considered as propagating, and the phrase subjected to Clause 4 does not actually prohibit propagation altogether, but only allows for regulation and not to outright denial in general. Furthermore, in applying Article 19 of the Universal Declaration of Human Rights, Barisa is basically exercising his right to freedom of opinion and also expression, as mentioned in the article. And by learning about Islam and attempting to share his understanding with the other Muslims. This includes the freedom to basically seek and also receive information from online religious websites, and also to impart it by preaching to the Muslims. And now moving on to applying the case of Utusan Melayu versus Datuk Sri Diraja Adnan, where basically Barisa's act of preaching at the mosque was considered as a genuine desire to share his Islamic teachings, which he has learned, which basically falls within his constitutional rights of freedom of expression and also freedom of speech under Article 10, which is considered as a religious view. And just as the court in Utusan Melayu basically protected the rights of private individuals to speak on matters of public interest, basically, Barisa, in our scenario, as a private individual, giving his speech was peaceful and also religious in nature, basically deserves similar protection under Article 10, Clause 1A. So next, applying the case of Muhammad bin Daud versus Government of Malaysia to Barisa's situation, his act of preaching Islam in the mosque was considered as peaceful and non-violent, and it was done in good faith directed at the fellow Muslims. And there was no evidence that is mentioned in the fact that his action actually caused any form of disharmony or public unrest or against public interest or public order between Muslims or other religions. So therefore, in conclusion, we can see that not all religious sharing or discussion amounts to formal teaching, and his actions do not fall within the category of propagation that justifies restriction, where in this situation, Barisa has the right to actually teach in the mosque. So therefore, in conclusion, for the first issue of whether Barisa has the right to teach in the mosque, yes, it can be concluded that Barisa has the right to teach in the mosque as long as it does not go against public order or disrupt the society's safety.
Now, for the next issue is whether the Imam has the right to restrict Barisa's teaching. In determining whether the Imam has the right to restrict Barisa's teaching in the mosque, one must consider both the federal constitution, especially its provisions on religion and freedom, as well as the state jurisdiction over Islamic affairs under Malaysian law. This issue requires a nuanced understanding of constitutional law, administrative powers over Islamic institutions, and the regulation of religious propagation. To begin with, Article 3, Clause 1 of the Federal Constitution states, Islam is the religion of the Federation, but other religions may be practiced in peace and harmony in any part of the Federation. While this provision upholds the special position of Islam, it also forms the constitutional basis state control over Islamic affairs, including mosque governance, Islamic education, and religious propagation. Now, next provision is the ninth schedule, list 2 of state list. Crucially, this list matters concerning Islam, including the administration of Islamic law and the regulation of religious doctrine. Rituals, mosques, and Islamic education fall under the exclusive jurisdiction of the respective state legislatures. This means that each state, through its Islamic Religious Council, Majlis Agama Islam Negeri, is empowered to enact and enforce laws that govern who may teach, preach, or disseminate religious views within mosques or other Islamic institutions. These laws typically require any person wishing to teach Islam in public or private forums, including mosques, to obtain a tawliah or formal accreditation. Now, one of the article that really relates to our issue is Article 11 that we talks that tell about freedom of religion. Article 11 Clause 1 stating that right to profess and practice religion. But in our issue, the constitutional legitimacy for this regulatory framework is found in Article 11 Clause 4 of the Federal Constitution, which states, state law and in respect of the federal territories of Kuala Lumpur, Labuan, and Putrajaya, federal law may control or restrict the propagation of any religious doctrine or belief among persons professing the religion of Islam. This clause explicitly permits the state to impose legal restriction on the spread of religious doctrines within the Muslim community. While the Article 11 Clause 1 guarantees to every person the right to profess and practice their religion, the right to propagate Islam, particularly in public or instructional setting, is subject to regulation and control by the state authorities. This legal position is further supported by various state enactments. For example, in Selangor, the Administration of the Religion of Islam State of Selangor Enactment 2003 under Section 118 states that it is an offence for anyone to teach or deliver a religious lecture without obtaining tauliah from the Majlis Agama Islam Selangor, MAIS. Similar laws exist across the states, such as Wilayah Persekutuan, Johor, Kedah, and Kelantan. Therefore, these laws empower the imam who acts on behalf of the state religious council to prevent unaccredited individuals from delivering religious instruction. A religious administrative perspective, the role of imam is not confined to leading prayers only. The imam also is entrusted with ensuring the activities within the mosque, including lectures and preaching, comply with state section doctrines, and maintain the doctrinal purity. Thus, his authority includes the right to prevent unauthorized individuals from delivering religious instruction. Now, the case precedents that relate to our issues. First case is Mio Atikur Rahman bin Ishaq versus Fatimah. So in this case, involved students who wore turban to a national school and claimed that it was a religious obligation. The legal issues in this case is that whether wearing the turban was protected under Article 11, Clause 1 of the Federal Constitution, held that the federal court ruled that while freedom of religion is protected under Article 11, Clause 1, it is not absolute. It must be read in harmony with Article 11, Clause 4. So the significance in this case is that the court clarified that religious practices could be lawfully restricted if it affects the public order or falls under the scope of state laws regulating Islamic affairs. Demonstrated that personal religious interpretation is not always legally protected when it conflicts with state-sanctioned religious norms. The next case is Sulaiman Takrib versus Kerajaan Negeri Terengganu. The facts in this case, a preacher delivered religious lectures without tauliah certification and challenged the legality of requirement. Therefore, the legal issue is whether requiring a tauliah infringed his constitutional rights under Article 11, held that the federal court upheld the validity of state law requiring tauliah. The reason in this decision is that the requirement to obtain accreditation before teaching religion is not unconstitutional. It ensures that religious teachings remain within the bound of doctrinal correctness, preventing the vain ideologies or teachings or confusion within the Muslim community. The significance in this case reinforced that state religious authorities have legitimate constitutional power to regulate who may teach Islam. It is a lawful control, not an infringement of freedom. To summarize, the court consistently recognized the importance of state control over religious doctrine and instruction. That every individual freedom to practice religion does not extend to formal instruction without proper accreditation. The role of the state and its agents, imam, in ensuring religious purity and avoiding doctrinal confusion is constitutionally valid and legally enforceable.
So moving on, now we are going to apply all the rules that I have mentioned by my friend Irfan here in our case. So in applying this principle to the facts of the case, Barrister here, although enthusiastic and well-intentioned, he actually does not possess any formal religious training or credential, such as from the relevant state religious council. He also admits to never having attended any religious classes or learning how to read Quran where he cannot read properly. And his knowledge is also self-taught through various online sources, which the credibility may be questionable. And when we talk about his action was not mere casual conversation. Instead, it is more to the act of preaching within the mosque without any tauliah. Now that we already understand about the background of Barisa, next we are going to see the exact legal violation that happened. So it mainly concerned with the teaching of Islam without any tauliah. So since Barisa here lacks formal religious education and does not possess a tauliah, his act of preaching in a mosque may be in breach of a state Islamic law, regardless of his personal intention or belief in religious duty. So if we were to assume that Barisa lives in Selangor, under the administration of Religion of Islam, State of Selangor Enactment 2003, under Section 118, Barisa here may be committing an offence for teaching or delivering religious lecture without obtaining tauliah from Majlis Agama Islam Selangor, or known as MAIS. Therefore, while Barisa here may claim that the right to freedom of expression and religion, these rights are lawfully regulated under state law to ensure proper administration of Islam and to prevent the spread of unauthorized or potentially inaccurate teaching. Furthermore, here Barisa claims that his constitutional rights are being violated. It actually does not hold when weighted against Article 11, Clause 4, which explicitly permits the state to regulate propagation among Muslims. So his claim to stay in a mosque and teach freely without oversight could potentially undermine the public order and doctrinal integrity, justifying the state intervention. Other than that, Barisa claim under Article 10, Clause 1A, freedom of speech here does not apply in this context also, as religious instruction is a regulated domain and not a matter of mere opinion sharing. So now that we understand the background of Barista as well as the legal violation that happened, we are going to move on to the role of Imam, which is in this context, where the Imam here actually acts as a guardian of a doctrinal purity within the mosque. So he has a duty to enforce state religious law as stated previously, for example, section 118. So he is actually entrusted to intervene when unauthorized individual preach, which is in order to prevent deviant teaching or confusion. Hence, his restriction on barista here was not personal or oppressive, but a lawful and necessary action under both state law and religious duty. So moving on, we are going to apply the case law that has been mentioned in our rule, in our case here. So, applying the principle from Sulaiman Takrik versus Kerajaan Negeri Terengganu and others, the state's requirement that individuals obtain a tauliah to teach Islam is actually considered as constitutionally valid restriction. So, as Barista lacks such credential, his action here fall outside the bounds of a constitutionally protected religious practice. The Imam's intervention prevents unqualified and potentially misleading teaching here, which serves to protect public interest and align with Article 29 Clause 2 of the Judicial, which allow lawful limitation on freedom for the sake of order and morality. Moreover, we are going to also apply case of Neo Atikur Rahman bin Ishaq versus Fatih Masihi, where although Barisa here motivated by a hadith and belief that he is fulfilling a religious duty, his lack of formal religious education and qualification raises concern about the accuracy and legitimacy of the teaching he conveys. So the Imam intervention may be justified to prevent potential misinformation where maintain religious order in the mosque and ensure teachings are done by a qualified individual, which is consistent with the legal reasoning in Neo Atikur Rahman, where it allows state to restrict religious practices when necessary, and in Barisa scenario, it is actually necessary. So to further solidify our argument here, we would like to also point out our views in the terms of public interest and harmony. So if we will allow individuals like Marisa here to preach without any credential, it would actually jeopardize our religious harmony, where it would be at risk of a propagation of false teaching which will undermine the credibility of most authorities. So the Imam restriction here actually uphold the public interest, doctrinal integrity, and religious order as permitted under Article 11 Clause 4 and supported by Article 29 Clause 2 of Judicial Shar. So to conclude our second issue here, we can see that Barsa's conduct is considered as unlawful even it is driven by a sincere intent. Whereas for the Imam, his action is considered fully justified, first of all under the Federal Constitution Article 3 Clause 1 as well as Article 11 Clause 4. The state enactment also support the Imam action where the state enactment lay down the requirement of a person to be tauliah before they can preach. The judicial precedent, two judicial precedents stated earlier, also supported the Imam action as well as the actual Islamic teaching that emphasise a qualified instruction before a person can preach. Therefore, Barisa's claim of constitutional violation is considered to be unfounded. So before we end, in conclusion for both issues, while Barisa here possesses a fundamental rights under Article Clause 1A and Article 11 Clause 1 of the Federal Constitution to express and practice his religion, these rights are not absolute and must be read in harmony with Article 11 Clause 4, which allow the state to regulate the religious propagation among Muslims. So the Imam restriction against Barisa teaching in the mosque is therefore constitutionally and legally justified under Islamic law, particularly if Barisa lacks formal credential or a tauliah. As affirmed in the decided cases above, the state has legitimate interest in ensuring doctrinal purity and preventing misinformation within the religious institution. Thus, while Barisa's intention may be sincere, his lack of qualification lawfully empowers the Imam to prohibit his preaching in accordance with the constitutional framework and the state enactment regulating the Islamic affair. So that's all for our group. Thank you very much.